Just while casually scrolling on my Instagram, I happened to stumble on Shantanu Deshpande's this video.
A lot of companies were born in the 21-22 funding boom. इन्होंने बड़े बड़े एंजल राउंड उठाए थे यार, 8 करोड़ 10 करोड़ 6 करोड़. And I must have made maybe of all my investments, maybe 4 or 5 founders, kind of did a good job of keeping angels updated. मतलब हर महीने हर क्वार्टर कुछ एक पन्ने का update. And suddenly like in the last 6 months I've gotten like 5 or 6 of them reach out and say, "Yeah, we run out of money." How can you run out of money? Like you know you're running out of money a year before it happens. हाँ बट तूने हाथ पैर मारे क्या? Did you do everything possible? Did you ask for help? Was there a strategic buyer we could find? Can we bridge the company? Something. मतलब I cannot imagine a near death situation where I'm not doing everything. हाथ पैर मारना, सबको कॉल करना, like just scream and shout for help, or just nonchalantly people are shutting down businesses. Very very poor यार. मतलब ऐसे लोगों को फिर से फंडिंग नहीं मिलनी चाहिए मेरे हिसाब से.
Now, as you just saw the video, Shantanu is emphasizing here that it is the duty of the founders to actually keep the angel investors informed. However, in order to avoid these situations where the angel investor is not informed, what legal steps can you take is exactly what we will discuss in this video. Now, if you are an angel investor, the solution to this problem is pretty simple, and that is to have everything in writing and to keep the founders bound by it. And after understanding this very simple thing, the second question that can arise in your mind as an angel investor is that where and how do I put it in writing? So the answer to this question is whenever you are executing a share purchase or a share subscription agreement, ideally after that you should also have a shareholders agreement. And it is exactly in this shareholders agreement you should have a right to information clause. And it is exactly in this clause you and the founder both get to decide as to how much access of information you'll have and at what durations. Now let's say you do not want to become a burden on the company as an angel investor, then you can have a right to speak to the founder, have a call with them every 3 months for an hour or so. But if you want more information, you can have the board resolutions of the company to access to. Or if you are like Shantanu, who wants to be made aware of any red flag events happening in the company, because like he said, if those events are figured out at the right time, then future losses can be prevented. In that case, you can define those terms as well as have access to information in case those events actually happen. But in short, eventually it's always better to have things in writing than to leave them in oral understanding.